waive off the profits, losses in the name of purchase. So everywhere there is money. Money is the only criteria. And as human beings we are prepared to do anything and everything for the sake of money. We are only interested in the end, not the means. That's the unfortunate position that prevails in the country today. I don't know about the world. It may be worse than this. So therefore, these disputes do arise. Now, if it is a dispute regarding the shareholders' rights, obligations, Companies Act provides for a remedy. Similarly, the latest law about commercial disputes, Commercial Courts Act, that also speaks about shareholder disputes. That means those disputes are away from company law courts, and we have two forums where these disputes can be resolved. Maybe some also go to the civil courts. Now the question is, the very idea of this alternative dispute resolution is, the existing system is not able to deliver the goods at a rate expeditiously. So therefore, to have a peaceful atmosphere in the society and to carry on business peacefully, as dispute cannot be avoided, we wanted a dispute resolution mechanism. Though there are several dispute resolution mechanisms like mediation, conciliation and so on and so forth, in India, I think arbitration is successful when compared to the Western world. So now the question is whether these disputes could be resolved through arbitration. So what is the problem in this country? Who decides? But one thing is certain, the condition precedent for referring a matter to arbitration is there must be an agreement in writing between the parties. Without that, there is no question of arbitration. Now the problem is, even after a written agreement in writing, can all the disputes which arise under the company law, I think between shareholders, can it be referred to arbitration? Now we have a wonderful Arbitration Act passed on the basis of municipal law. So many authorities are deciding this question. Section 8 of the Arbitration Act confers power on the civil court or the commercial court to decide whether a particular dispute is arbitrable or not, whether an objection is taken in a suit. Section 11 confers power on the Chief Justice or his nominee to decide whether a particular dispute is arbitrable and then appoint an arbitrator. It doesn't stop there. We have section 16 which says the arbitral tribunal shall decide even the existence of an arbitration agreement, whether the dispute is arbitrable or not, and therefore the matters are sent to them by the High Court many times. It doesn't stop there. After an arbitration, an award is passed. Section 34 2A and 2B provides for setting aside an arbitration award on the ground that it was not arbitrable. So many factors. The High Court, the Civil Court, the designated arbitration court, before arbitration, after arbitration, the question of arbitrability is agitated, decided. The very purpose of this alternative dispute resolution mechanism, I am afraid, is defeated. So in this context, today what is troubling the legal fraternity is what should be done about these disputes pertaining to shareholders and investors if they want an expeditious, speedy and more importantly satisfactory resolution of dispute. Sometimes we feel dispute is sometimes I have seen in the tribunal constituted the Companies Act, within a month or two, case is disposed of, not decided. Is it that what you want? You want a decision on merits, satisfactory, or a disposal of the case? Of course, some judges are very fond of saying I have disposed of so many matters, not decided matters. Now today, I am afraid, majority of the cases in courts are disposed of rather than decided. That will be a death knell to the arbitration proceedings at all. Especially in a case of arbitration, especially in case of commercial arbitration, the parties are not illiterate. They are highly qualified, moneyed people, engage the best talent in the country, and they choose the best possible arbitrator. And at the end of the day, case is not decided and disposed of, and that too not satisfactorily. There is something basically wrong with the system. So in this context, the persons who are involved in arbitration, the lawyers, the advisors to the lawyers, and the arbitrators should open their eyes. If the system has to survive, you cannot expect the legislature to provide for everything in the law. What best they could do, they have done it. Ultimately, it is for us to work the system. And what the Supreme Court says is final. That is right or wrong is a different thing, but it is final and we have to follow it. Now in this context, in all the forums, this question is agitated. First they say there is no arbitration agreement, though there is a agreement. They say this particular dispute is cannot be referred to in view of this clause. Read these sections. Now of course we have a 7-judge judgment recently, probably very liberally interpreting this and saying, if you can bring within the four corners of arbitration something, you bring it, doesn't matter. Now the next question is, that also we have a latest judgment. When this objection is right regarding arbitrability of any dispute, including the shareholders and investment dispute, is it the civil court or the high court? Don't go deep into it. Prima facie, if you are satisfied, refer the matter to arbitration. So this is what the legal position appears to be. But in the case of shareholders and investors disputes, always it is not a dispute between the two shareholders in the real sense. Now the Supreme Court has said, dealing with company laws prior to the present amendment, latest law, the arbitrator has no jurisdiction to go into the question of winding up as well as insolvency proceedings. That law continues to be the same. That is not the only litigation which arises under the company law. We have petitions filed for merger and amalgamation of companies, and we have petition filed for winding up of the company on the ground of oppression and mismanagement, and also for winding up of these proceedings. Now strictly speaking, all these litigations, the ultimate judgment rendered is a judgment in rem. Therefore, the real test according to me, to decide whether a particular case under this company law is arbitrable or not, is find out whether it is a purely a private litigation, that is a dispute in persona, or a dispute in rem. If it is dispute in persona, certainly the arbitrator has jurisdiction. That's precisely what the Commercial Courts Act also says. The definition of commercial dispute includes shareholder agreements, disputes arising under the shareholders' agreements. If the commercial court has got jurisdiction to decide that case, and if there is an agreement to refer the matter to arbitration, certainly the arbitrator will have jurisdiction to decide those disputes. Divorce those disputes arising under the Companies Act. The test is it purely a dispute between two shareholders, or the ultimate order to be passed is a judgment in rem. For example, in winding up proceedings, creditors are involved, other debtors are involved. It is not a matter purely between two shareholders. But many times it is a dispute between a minority shareholders and the majority shareholders. It is not necessary in all cases the ultimate order to be passed in the winding up proceedings. There are other remedies available. So even if those cases are not referred to arbitration and it goes to the regular courts, even if the parties have an intention to compromise, that is not possible because of the delay in disposal of those cases. So at that stage, what should be the approach? Approach by the lawyers, approach by the judges, and how the law is to be interpreted. Therefore, in my view, my understanding, the real test to decide whether a particular matter has to go before arbitration or to the regular court under the statutes is find out is it a dispute in personam or dispute in rem. If it is a dispute in rem, arbitrator probably cannot deal with those matters. If it is purely personal, then he could decide. Many times it so happens a dispute in rem also includes a dispute in person. Then the question is, can you separate it? Where third parties' interests are concerned, to that extent the dispute can be decided by these tribunals or courts, and where it is purely personal, can that portion be referred to arbitration? With this introduction, we have in this panel persons who are actively participating in these proceedings. So let us see from the lawyer's perspective what they feel. Do they feel there is any shortage in the law or shortcoming in the arbitrators or shortcoming in the process itself? So I request our eminent lawyer, I think he has put in more than 20-25 years in this particular branch, let him share his experience both in Bangalore courts, now that he is in the High Court, and also in the Supreme Court. Courts are courts, but experience is different. Not necessarily, let me tell you very quickly, we are discussing right now. It is my experience, I am a part of this Judicial Academy. I had an occasion to train our judges, especially district judges, when the commercial court was formed. I think I took 2 sessions. When persons are appearing before those courts tell me, majority of the commercial court judges are very good and we are getting speedy relief, satisfactory relief, then I feel our efforts in the academy has not gone waste. So therefore, Supreme Court is Supreme Court, High Court is High Court, Commercial Court is Commercial Court. But the more important thing is who is the judge presiding over there. Ultimately, it is the judge who counts and not the court. Maybe what the Supreme Court says, right or wrong, it's binding on us. That apart, as far as administration of justice is concerned, analyzing the facts, understanding the law and applying the law to the facts and ultimately doing justice is done by every judge. And whoever has done the judge, whether he is a district judge at the district judiciary or the Supreme Court judge, he requires, he commands a great respect from the members of the bar as well as from the public, because he is an educated public or before the court in these matters. They understand. Many times they know better law than us. So therefore, it was interesting to know what the persons who are actually practicing and who are assisting the courts and the arbitrators in administering justice have to say about the law and the process which is being undertaken now.
Thank you, sir. Honorable Justice Kumar, the chairman of this panel, honorable judges and former judges of the High Court. The 2 former judges here are the 2 judges in whose court I have been chiseled and brought up as a lawyer, 16 years in your court and possibly 6 or 7 years in Justice Anand Beda Reddy's court. Fond memories, and I'm glad that I'm getting to speak in front of you. Other members of the judiciary, friends from the bar, this is homecoming for me. I'm coming back to my parent jurisdiction, so let me be a little critical and possibly a little honest. It may not be to everybody's liking, but I think the idea of a conversation of this nature on home ground is that you can be open and candid about it. The topic seems to be crafted so that we can kind of suit to say something under it, because if you say arbitration of shareholders and investor disputes, most shareholder disputes are operation and mismanagement, and they are purely non-arbitrable, as everybody in this room will indicate, so there is nothing to speak about it. But I come from my experience in terms of how this is actually morphing itself to being a large quantum of practice, and therefore the bar in this city and generally in this country is losing out on that work, because that work is typically centered around Singapore or London. And I say that with a few examples. 3 or 4 points. I know that my fellow panelists will have much more to say, given that Murli and I come from a litigation perspective, but the two others who are here, Vipin Mehta and my friend Udayankar, are the ones who actually create this dispute, because they end up drafting those contracts. So thank you. Good work for us. There are 3 or 4 things which for me are glaring. The whole jurisprudence that developed from Booz-Allen, Hamilton to ultimately Vidyadrolia and the rest of them to indicate that in-rem disputes are really outside the scope of arbitration is fantastic when you look at it from a jurisprudential perspective. But there is no guidance in any of the judgments in terms of going through the material and having a sieve to indeed decide whether this is in essence a dispute which is actually leading to an in-rem solution or in-personam solution, because every shareholder dispute in some form or the other is camouflaged as an operation mismanagement action. The minute you know that it's a shareholder dispute and you would like to arbitrate, you will be faced with the proceedings in the jurisdictional NCLT indicating that there is an operation mismanagement action. And in my experience, and I've been critical about it, a section 8 or a section 45 filed before the NCLTs today is not going to see the light of the day. That's been my experience. Absolutely not. You can do what you want, you can break your head before that bench, you will get nothing in terms of an 8 proceedings. The minute an 8 or 45 is pending, any arbitral tribunal, whether ad hoc or institutional in any part of the world, generally tends to defer to it, saying that you get us that judicial order, we'll take it forward, barring a few examples which I will give as illustrations. Second, I think therefore there is a need to relook at that jurisprudence, not to say that in-rem disputes should also become arbitrable, I don't mean that, but relook at that jurisprudence to actually try and have bifurcations or more granular approach to indicating how should it be considered in-rem or not in-rem. That's one thing that's possibly for the courts to do. Second, I really think there is a legislative intervention necessary in cases of this nature, because the horse of legislative intervention I think will take 10 years before we even come down to some granular approach of how we can move investor disputes and shareholder disputes into arbitration. Third, unfortunately for us, as we go along, the judgments that are coming out from our courts, be it high courts or Supreme Court, whilst attempt to actually give you a greater jurisprudential analysis, the net reading of those judgments just simply, let alone giving us guidance, confuses the pot even further, indicating whether we can push or not push for arbitration. Fourth, and this is something I'm critical and consciously critical about it, and I agree, we were having a conversation with Justice Kumar on this, I fully agree with that endorsement. The situation is that I think the reason why arbitration in this area is really not going forward, there is only one section of this entire stakeholders to be blamed, and that section is the lawyer section of it. There are the judges, there are the arbitrators, and there are the lawyers. When it comes to lawyering in this area, the first essential aspect of lawyering in this area is to make sure that you can actually identify the dispute, remove the non-arbitrable parts of it, identify the arbitrable parts in a shareholder dispute, and proceed to go to arbitration. The two lawyers in this dispute don't seem to agree on it. And therefore, unless you have a robust arbitration bar, taking a decision like the West does, again, I have an example to give you on that. Like the West does, where the bar takes a decision saying that, all right, the two lawyers, the two law firms indicate that yes, this part of the dispute is arbitrable. So let's not raise an objection to that arbitration. Let's proceed forward with the arbitration. And the ones which are non-arbitrable and require in-rem dispute resolution, we will go to the tribunals or the courts or whatever it be. Now, why is that lawyers are to blame? Because first, we do not exercise that discretion of indicating what should be arbitrated. Second, more importantly, we do not exercise the discretion which we get from our experience to identify the right arbitrator for it. And you're right, sir, that in most cases when I ask for arbitration and you say no and we are in a level, we leave it to the court to appoint an arbitrator. And that's, I think, the last thing that we should do in a matter of this nature, because we require specialized arbitrators in it. Unless you have an arbitrator who has gone through this matrix, if not internationally, at least from a domestic perspective, it is impossible for you to take that forward. Now, of course, there are multiple illustrations. Why did, of course, the two Ambani brothers dispute is always brought up. Why did that not get arbitrated? Why did it get mediated? Because I think everybody advising the spectrum realized that if you go into arbitration, you will go nowhere. If it goes into the CLBs or the NCLBs of the world, it's even worse. And therefore, better not to really venture into that spectrum. Let's mediate and settle the dispute, which is actually a shining example of saying mediation is good, but it is even more a shining example of saying that arbitration and dispute resolution in this mechanism, even if it is ignorant dispute, is horribly bad in this country. And therefore stay clear from it. Illustratively, on the tech side, on large infrastructure side, Ms. Mehta will have that experience in terms of large infrastructure contract, and on the general FDI side, there are disputes as we speak. For example, a very, very large builder from the Middle Eastern spectrum, one of the largest infrastructure and builder kind of company from the world, had a very, very large JV in this country which just did not take off because the Indian shareholders, who were minority, really worked the system in the manner that they could, leading to a whole-scale shareholder dispute which became a operation mismanagement action which is going on in multiple courts in the country. But fortunately, because they were advised by possibly the right set of lawyers in terms of two large firms in India and a bunch of very mature large firms in the West, they realized the folly of continuing those proceedings before the NCLT for 4.5 years and getting nowhere towards resolution, that the lawyers decided to carve out a significant portion of that dispute whilst keeping the operation mismanagement action pending on the files before the NCLT in Delhi, the principal bench, carved out a portion of the dispute and indicated that this could be referred to arbitration. Arbitration was under LCIA, therefore seat was London. But even there was a dispute on what is the quantum of that dispute which will go into arbitration. And fortunately, a set of arbitrators who are experienced in the scenario put their foot down and said that according to us, A, B, C, D, E, F is arbitrable and we will proceed. They proceeded. The NCLT proceedings went in parallel. In under 12 months, you had a brilliant award in arbitration which indicated what should be the resolution. That was brought back to the NCLT and filed in a sealed cover because there was confidentiality surrounding the award, etc. And the NCLT took it up saying that yes, this is now giving me some guidance in terms of how I should now resolve the operation mismanagement action. First, I don't need to wind up the company. There is an answer that is available without winding up the company. That, according to me, in my little life, is a shining example of how arbitration of shareholder disputes, even though it's camouflaged as an operation mismanagement action, even though pending in the country, can get arbitrated. But the sad part of it is, why should it get arbitrated outside? The parties, this is one dispute which had LCIA, it had an international party, etc. There are multitude of such disputes. The same formula applies and can be arbitrated in this country, but others may have examples. I do not have a single illustration to give you. Now the reason, if I don't have a single illustration to give you, logical sequitur is there aren't any such cases that are available, which means that the whole practice is in a black hole. I will only end by indicating that I think the test of looking at whether a particular dispute is arbitrable or not should be looked at from a practical sense. If Supreme Court says to read a contract, apply Penta principles and give a business efficacious interpretation to the contract and not a jurisprudential interpretation, I ask myself, why is that we are not giving a business efficacious interpretation to the dispute first, forget the resolution. Everybody, both sides of the dispute know what the essence of the dispute is. How is that you can, first attempt of a lawyer is not to convince the judge. First attempt of a lawyer is to first convince his or her client, indicating that this dispute is bifurcable, that one portion of it can go to court, the other portion should go to arbitration. Now if lawyers don't do that, in order to, again, I'm being critical, in order to please the client or let the client listen to what they want to listen, you don't want to tell the client that I will push it to arbitration, because you believe if you do so, the client will move on to the next lawyer, then there is no right to it. But if you do so, and that leads to a situation where at some point of time there is granular approach to a further rendition. Booz Allen is
fantastic law. It comes down to Vidya Drolya, becomes even clearer, and the rest of it, all of it correct. But somewhere these disputes must land up in court for a more granular approach of indicating that within this whole matrix there can be a subset. We see the subset internationally. We see that in infrastructure disputes. We see that in large FDI in terms of real estate. We see that in tech disputes. Why is that you do not have tech disputes in court today? Of course, the largest tech disputes in this country are all antitrust and competition disputes where the regulator is trying to get after the tech company or otherwise. The tech company trying to skirt the regulator. Those are the disputes. Free speech is a dispute. But we are all lawyers here in the room, can you even think of a dispute where a shareholder dispute for big tech has landed up in court? No. Why isn't there an operation mismanagement action from any large big tech player in the country? Is it because they are better human beings and they don't fight? Answer is no, that is not the case. There are fights. But the scenario is those resolutions happen. They happen through mediated settlements or arbitrations, but unfortunately happen outside the country. I just want to bring that into focus and indicate that if we need that change, I think as lawyers, that change should begin from us. We can blame the system, we can blame the fact that, quite frankly, I think everybody in this room will agree with me, they may not want to say so loudly, the NCLT experience is just not working. And I think the louder you cry and shout about it, the better it is. The government, first it is not working, but the government wants to spend more money, our taxpayers' money, to create more NCLTs. Now I do not know how that's going to be a solution at all. We need horses to run the derby. We have goats available. We want to buy more goats, and they say, all right, now we will get the derby. It's just not going to happen. And therefore, it is in the interest of the bar, therefore. Forget anything else. Justice Kumar will look at it from an institutional perspective because he had the guts, the rest of you here had the guts to leave lucrative practices and get onto the bench. We didn't. We're still in terms of, I'm a hardcore capitalist, I would never do that. But therefore you will look at institutional scenario. I am not looking at institutional scenario, but I am looking at a capitalistic answer which will actually build an institution. All that you need to do is to make sure that these disputes are bifurcated. The need to bifurcate it. Do we have intelligence in this country to resolve it? Yes. Do we have judges who are capable of resolving it? Yes. But please choose the right retired judges to be arbitrators for you if you want retired judges. And for once also please have an institutional change. You have enough number of counsel. People who practice in that area, they need not be designation is a tag, you should throw it out. You don't need that designated, but you have some brilliant counsel, for example in law firms, who know the nitty-gritties of how it actually structures. But I have not seen a single arbitration in which I get a senior partner of a law firm to become the arbitrator. Why? Because as lawyers, we don't want to trust a competing firm. There lies the problem. And that's my 2 bits. I'm conscious I've taken more time than necessary, and thank you, sir. And back to you.
Good afternoon, everyone. Honorable Justice Kumar, I'm privileged to be part of this panel. My fellow panelists, former judges, fellow professionals. So, we have spoken about in-rem contractual. Let me dive straight into this. Most of these contracts, the shareholder disputes arising from contracts, nowadays, my friend will also bear with me, mostly deal with investors on one side and the promoters on the other. They are the structured contracts where there is an investment coming, so it is a well-drafted contract, and all these have arbitration clauses. There's no difficulty there. When there is a dispute, there is a it can be referred to arbitration. So the reason, we are generally talking about shareholders dispute, arbitrability, the viability, feasibility of arbitration, vis-a-vis what are the other remedies going to the NCLT, the operation mismanagement case, the Booz Allen case, which my friend Sajjan Bhuai also dwelt upon, which has clearly said out whether the dispute is arbitrable and whether there is an alternative forum available. Based on that, you decide whether it is arbitrable or not. So in many a case, what happens is, from my experience, what I see, the investors want exit at some point of time. They are here for the money. Justice Kumar said it's all boils down to money. They have invested, they want an exit. So the agreements typically have a put option or a call option, drag, tag, you all know about it. They seek to enforce those agreements, those clauses. So it is very well, the agreement has an arbitration clause. Simple thing is invoke the arbitration clause, refer it to arbitration. But on the other side, you have the promoters. Many of the situation, one, either there is no money to give them the exit, or there is a sheer unwillingness to give them the exit. So for the as a lawyer, the promoter comes to me, I am trying to protect his interest. What do I do? If you go for arbitration, it is simple. The clause is there. Go to arbitration. 9 out of 10, the investor will succeed in his prosecution of the thing. It will be awarded. So if the promoter comes for whatever reason, how do you resist it? Then you have to say he is oppressing me. There could be a deadlock situation. Then you dress it up and go and file an operational mismanagement case. That is what has typically happened in this case of this Westbridge cases. Where on the one hand, the investor invokes the arbitration agreement. Yes, like in all these things, like my friend Sajjan said, all these arbitration clauses have seat of arbitration at Singapore, London, the ICC rules, SIAC rules. None of them are subject to Indian arbitration. So somebody files there. So what does the Indian promoter do? You are oppressing me, and files an operation mismanagement case. That is what came up. There is an anti-suit injunction, then anti-enforcement. So parallelly things start. So to put it, I mean, it is inevitable. The promoter wants to protect his interests. So the other side says you have dressed it up as a operation mismanagement case. And you have sought your remedy before the NCLT. Whether the NCLT you get the desired result or not, that is a separate talking point. Today we don't get anything there. Finally, the Bombay High Court says, so what? I mean, you can always come back to the NCLT, file an application under Section 45, and say it has to be referred to arbitration. Matters stands there, it is running parallelly. So it is a fine thing whether it is in rem or it is specific to a party. So typically what happens is, if I don't want an arbitration, this route is available, and I put in all these typical clauses saying it is just and equitable that the company has to be wound up. The conduct of the other side is harsh, burdensome and wrongful. The Supreme Court said you have to plead all these in an operation mismanagement case, and it is prejudicial to the interest of the company, its members and the public. Then it becomes rem. Then it boils down to now the difficulty comes if such a petition is filed and the other side files a Section 8 or a Section 45 as the case may be. It is for the company law board, the NCLT now, to decide whether it is in rem or it is arbitrable or it has to be continued there, and it is within its jurisdiction. So we all know the difficulty we are seeing. My friend Sajjan also pointed out the Section 8 and Section 45 petitions before the NCLT do not see the end of day. That is where probably a legislation has to come, because after all these come out of shareholder disputes. Either specifically say in these proceedings, if a Section 8 or a Section 45 plea is taken, it must be disposed of within a specified time so that it moves on to arbitration. Today, if you ask me as a lawyer, what remedy do I have? File it, the NCLT will sit on it, will not pass any orders. Today, it has become an order to take every single order or non-action of the NCLT to the High Court under a writ and get directions and say, decide that Section 8 or Section 45 immediately or within a time span, and then go. If it is an arbitrable matter, let it decide any which way, and that can be finally decided. So, this in rem and whether it is an arbitrable issue has to be decided upfront, and there has to be an intent. My friend Sajjan said there has to be something coming from us lawyers to ensure that whether it goes here or there. But honestly, I'm acting for my client. If I act for the promoter, he'll say another delay money. Don't be in a hurry to send it. I'm not interested in arbitration. End of it, I'm protecting my client's interest. It's all very well to say, we have to be responsible lawyers, no doubt. End of it, it is my paying client whose interests I try to protect. And the next point is, okay, assuming we go to arbitration, okay, we'll park the international arbitration, they are all, they're attuned, they are doing all these matters. But when you come to domestic arbitration, Justice Kumar also was saying, you're making the choice of arbitrators, so you ensure they have the domain expertise to do it. And how much domain expertise we have in the system today. Luckily, it was not a shareholders dispute or some dispute arising out of a share purchase agreement where the original promoter sold it to a corporate. There was some deferred payment and there was a dispute which went to arbitration. There was no operation mismanagement or anything. It was a straight out of the contract. Luckily, it was a three arbitrated tribunal. So each of us, one of us chose Justice Kumar, another party chose Justice Gururajan. Together they chose Justice Venkatraman as the third arbitrator. So it worked well. We chose rightly. End of it, there was an award. I partly succeeded, I partly didn't succeed. I could say I won and lost. So the same with the other case. So agree, you go to section 11, most of the times the High Court refers to a retired judge. Not necessarily all of them have this domain expertise. And that is where there has to be something from the institution point of view. Probably say in these kind of disputes, please refer to these people. If it can be done, nothing like that. So this domain knowledge, domain expertise in these kind of arbitration is very, very critical. And there must be a panel like, my friend would say, why not even professionals who can be arbitrators, need not necessarily be retired judges. There are some with domain knowledge, but not all. And why don't lawyers come and be arbitrators? It is not that nobody nominates a lawyer as an arbitrator. Very rarely, seldom do I see lawyers being nominated as arbitrators. And like I said, there could be a conflict issue. So, the domain expertise, and so long as there are, client kind of requirement where an arbitration has to be resisted in shareholders dispute, there are bound to be a parallel proceeding before the NCLT. Try to say it is dress it up or genuinely. You may seek a redressal for overall, say, an administrator has to be appointed for management of the company, or quite honestly, I don't see many cases where the NCLT or the erstwhile Company of Law Board or the High Court, when it had original jurisdiction, ordered winding up of the company, because it says where circumstances exist for winding up of the company, but that is not the right thing to do in the circumstances. That's what petition under 2 for operation mismanagement petition says. So in a dressed up petition also, if you call it a dressed up petition, eventually one has to see what the parties desire. If it can be clearly segregated that there are only 2 parties, there is an arbitration agreement, it has to be referred to arbitration, it is fine. But where there is an overlap between an arbitration clause and also where it could be one party being aggrieved, and once the management of the company to be set right, there could be cases where there are allegations of mismanagement of funds, diversion, forensic audit. These are all questions, one is whether an arbitral tribunal can go into all these things. So these will coexist. on the one hand, one party choosing to arbitrate to exercise its personal right, and the other party saying these are all rights in them and pursuing the remedy before the special statute, meaning the Companies Act. But there are certain things which have to be looked into where it is arbitrable. There must be a legislative intent to say where it is an arbitrable dispute, without much delay or ado, it must be referred to arbitration, perhaps by judicial precedent or a specific amendment to the Companies Act. This can be done. And of course, the most important thing is these are all nuanced. There are various clauses. I have not personally seen many decisions on enforceability of this drag along and tag along, put option, call option. These are all my two friends sitting at the end. They repeatedly put all these in the agreements. We see it very often. We agree, but we have to see what is the domain expertise of the arbitrators to understand, if assuming it is an arbitral tribunal, to see what are the enforceability of those kind of clauses. Definitely there has to be some level. I mean, we have not seen too much of judicial precedence on that. But again, those kind of things, people who draft these clauses, they should typically be part of arbitral tribunal to guide a tribunal and what is meant by this, how do you enforce. So these are the things which have to come out. Particularly, I'm just talking about shareholders dispute and what should come out of it and what are the areas which needs to be addressed. Domain expertise, definitely, and we definitely need to see these nuanced things arising out of shareholders dispute. So this is my two bits. I'm sure my friends will take it forward.
Thank you. And good afternoon, everyone. Thank you for joining us today. Thank you to the members of the panel. So a lot has already been said about the arbitrability of shareholders' disputes. Just to give a few points from a practical perspective as to what happens, right? And where the sort of overlap or the juxtaposition between a typical O&M dispute and a shareholders dispute. So as we all know, typically in a investment kind of a transaction, on one hand we have the founders or the promoters, and on the other hand we have the investors, right? And typically investors will have a larger stake in the company or larger shareholding in the company. Whenever a dispute arises out of a shareholders, a typical dispute arising out of a shareholders agreement, the latest one being the Anupam Mittal case, which I guess many people must be aware about. What they tried to do, the investors, is that they tried to exit the company and exercise their drag-along rights, right? Now, in exercising the drag-along rights, they sort of wanted to sell the company to the competitors. And obviously, because this stemmed from a shareholders dispute, the promoter or the founder, Mr. Anupam Mittal, he went and approached the NCLT. And he mentioned that these are typically, and the claim made by him was that this is a case of oppression and not a case of shareholders disputes, right? And on the other hand, obviously, the investor wanted to arbitrate the dispute because there was an arbitration clause. The seat was in Singapore. Unfortunately, why, according to me, the dispute panned out so much was because there was no lex arbitri that was set out in the agreement. So typically, if you see a construct of a shareholders agreement, now the position of law as it stands, and I think the most well-known case on the point still remains Rakesh Sharma's case by the Bombay High Court. The position that was taken, I think this was about 8 to 10 years back, was that O&M disputes, given their natures very nature, and the reliefs that are being sought pursuant to our O&M dispute under section 241 and 242 of the Companies Act. If the reliefs that are sought, which are mentioned under section 242, those reliefs, an arbitrator who's a creature of contract or a creature of the arbitration agreement may not be capable of giving. And hence, as law stood then, the order was passed that O&M disputes are not arbitrable. But of course, since then, the law has progressed quite a bit. We've now seen the slightly change in law taken by virtue of the Vidya-Drolia judgment, where even though at that point, Booz Allen sort of set out those 5 to 6 categories of disputes which were not arbitrable, which we all, I think, know, matrimonial disputes, testamentary disputes, or disputes which are barred specifically by another statute, right? So those were considered to be non-arbitrable. So from there, we progressed significantly after the Vidya-Drolia judgment. We've seen that, even copyrights and trademarks disputes, if they particularly deal with contractual infringements, then those may still fall within the realm of arbitration. So I think the law has progressed significantly, and so obviously, coming back to the Anupam Mittal judgment, and coming back to my own practical experience that we've seen whenever an investor tries to initiate an arbitration under a shareholders agreement, the first step that is taken by the founders is to file a claim for oppression. And it naturally happens so because of the clear overlap between the rights and obligations under a shareholders agreement, which all stem from provisions of the company law, and hence, and obviously also taking into consideration that you're talking about one traction of people like the investor who hold a majority right in the company, and there is one traction being the promoters who are typically minority. So it's very easy to then say that this is a claim of oppression and try to stall the arbitration proceedings. As a matter of fact, the Anupam Mittal's case started, I think, 5 to 6 years back when they tried to initiate the arbitration, and it's still pending before the NCLAT. So that's where we are because of all these issues. I think one point which we may sort of take into consideration, a lot has been said already about right in rem and right in personam. My understanding is that there are many other mature arbitral jurisdictions such as Hong Kong or London or Singapore, where they have similar provisions of oppression and mismanagement in their various company laws. But the stand that is taken is that the disputes which an arbitrator can decide, or what they tend to do is let the arbitrator come to the conclusion about the substance of the dispute, in the sense that there is nothing under law which says that the arbitrator cannot decide whether yes, there has been an infringement of a buyback provision or there has been an infringement of a drag-along right. Let him conclude that. If at all it comes to the remedy, suppose if the arbitrator decides that yes, the company has to be wound up, or there are any other remedies which fall strictly within the realm of the NCLT or any other body over there, then the NCLT can sort of give that, enforce that remedy. So I guess with time, maybe we might also reach to that position. We may, I feel, according to me, that may be a better position, that let the arbitrator decide, because at the end of the day, it's the parties to the contract who have given birth to the arbitrator. They've agreed that all the disputes that will arise between them. In fact, in the Anupam Mittal's case, I think one difference was that we typically see an arbitration clause which says that all disputes arising out of and under this agreement shall be subjected to arbitration. In fact, over there, they had also mentioned the term management disputes. So when the Singapore Court of Appeal was faced with this issue, they said that the parties in their commercial wisdom have agreed that even management disputes should be arbitrated. Then why should the party autonomy, which is one of the most important principles of arbitration, should not be followed? So I guess that is how things will proceed as in some years. Unfortunately, since Rakesh Malhotra's judgment, I have not come across any judgments which have travelled back to the Supreme Court for this position to come up again. So these are just my few points.
Thank you. Pleasure to be here and pleasure to have you here with us. Mr. Puve was just asking me, everyone seems to have said pretty much everything under the subjects, what exactly you want to talk about, which is true. I really have nothing much to add what the panel has already spoken about. I have, or rather I would just go into a few questions that I've always grappled with when you're advising clients. Why would I decide taking a statutory recourse as opposed to an arbitration recourse? It largely boils down to who am I representing. If I'm representing an investor, in most cases an investor would want efficacious remedy, a time-bound efficacious remedy. If I'm representing the promoter or the person who's in charge of the company, he would usually look to delay and frustrate for whatever reasons. In that case, as an investor, if the client were to ask me a question, should we do an oppression mismanagement or should we arbitrate the dispute? The concern that I would have is, one, I would not have a definitive answer because of inconsistent application of principles. Because if I tell the client that let's arbitrate, then you would have O&M petition being filed. Or if I tell the client let's do an oppression mismanagement, you're hit by a Section 8 petition or a Section 45 petition application. It becomes difficult then to tell a client confidently that the right recourse would necessarily be an arbitration proceeding, or it will be a statutory proceedings under the Companies Act. In light of this background, the question that I would ask the panel is, how would you decide that when you're advising a client, irrespective whether it's a foreign whether it's an investor, whether it's a promoter, how would you advise a client saying that go for this particular, you're likely to get your interim reliefs, your final reliefs are also likely to be a faster process as opposed to a long drawn out process?
Candid answer. Whilst it's fine in a conference to indicate that we could take the right attitude and refer the matter to arbitration, etc., the candid answer will be that I fully with you. We will do everything that is necessary. For example, if I was representing the promoter. Therefore, the answer to this question would come not from a perspective of what the law says. The answer for this would come from the perspective of which is the bench in NCLT hearing the matter. If this was before the principal bench, that is the president's bench, I would say let them file an 8, we will defend it. If this was Bangalore, I think all of us know what the answer is.
My answer is depending on who my client is.
After hearing the learned speakers, what appears to me a wishful thinking, of course, is this. Now, under the Indian law, when a matter is referred to mediation, conciliation, or even Lok Adalat, it goes before that. If it is not settled, it comes back. If it is settled also, it comes back. And an order is passed accordingly. As far as arbitration is concerned, once it is sent to arbitration, it never comes back to the court. It takes another route, Section 34 and then the appeal. After hearing them, what I felt was, all matters which the tribunal has got jurisdiction to decide, as we call it as in rem, could be referred to arbitration. Let him conduct an inquiry. Let him record a finding. And then thereafter it is placed before the tribunal which has the jurisdiction to pass the law. Now, in a sessions court, if the judge holds he should be hanged, he can only say he can be hanged, it cannot be hanged. It has to go back to the High Court for confirmation. Probably, if you can think of an amendment to the law, two things are achieved. The arbitrator, as our friend is an expert, will apply his mind, and at the earliest point of time, the dispute is resolved. All that the court has to see is whether the reasoning recorded is good or not, and he will have the full freedom to come to a different conclusion if according to him it is not satisfactory. But at the end of the day, it will be a judgment delivered by the competent court in pursuant to the statutory provision which confers power on them. And probably we can find out an appellate remedy to set it right. But as the law stands today, whether it is arbitrable or not arbitrable itself is a question. And even if the parties agree and an award is passed, that could be set aside under section 34 on the ground that it was not arbitrable. It is atrocious. So therefore, probably we have to move forward. If the advocates take the responsibility, which according to me they should do. Both of them said, I will act according to my client. Certainly you can act according to your client, but you are an officer of the court. If you are interested in developing arbitration as an alternative dispute resolution, some sacrifice from your side is also required. Without sacrifice, nothing is achieved in this world. The sacrifice the lawyers have to make it is, give them a good advice. That is the sacrifice I make. A good, competent advice, saying it's a good case for arbitration. If you go into that, though I can drag on the matter, in the end of the day, if something goes against you, you will be ruined. Unless a responsible, specifically arbitration bar is developed in this country, Arbitration Act will not be successful. On the contrary, the arbitration bar, which is at the moment is a part-time bar, is ruining the arbitration. So therefore, when we are talking here, no doubt everybody has a fundamental right except the judge. You have to exercise that right in a responsible manner. When we are talking here of how to improve the arbitration, how to improve the alternative dispute resolution, all that is expected of you is to give correct, competent, honest advice. And if you say, I can't give honest advice, then I will not get money. Well, it's for you to decide. But I personally feel, for example, in our High Court, we have the excellent tax bar. So like that, Karnataka should be a model. Our Karnataka advocates who are practicing on the arbitration side should be a model to the country. No doubt, it may hurt their personal interest, but in the larger interest of the institution, even in the larger interest of themselves itself, then more people will opt for arbitration. The more people opt for arbitration, your interest is also taken care of. Sometimes people want to make money only in one case. That attitude is not correct. You can make money, not in one case, in several cases.
Murli is older to me. Restart the trend.
So some change in mental attitude that is required if arbitration is to be sustained, and it should become a preferred alternative dispute resolution mechanism in this country. Because I don't want to comment on the tribunal, the constitution of the tribunals and their working. That is the reason why the Arbitration Act is there. The very fact we are talking about of alternative dispute resolution means the existing system has failed. We did not have alternatives in the country. Now we have an alternative. If we kill the alternative also, that's the end of rule of law and legal system, in which maybe many are interested. But as responsible citizens, responsible advocates, responsible members of the bar, especially those who are practicing the arbitration side, a little compromise, a little sacrifice on your part will go a long way, and we can make arbitration, even in respect of shareholders' title, even in respect of cases where judgment should be in rem, we could make a difference and we could be a model to the country.
We are not all irresponsible, sir. No, I mean, even in O&M cases or arbitration, we see who's the lawyer on the other side. If somebody we know that, we try to settle it. Invariably, all these shareholders dispute, whether it is before the CLB or here, one party seeking an exit. That's what settlement by exit of one valuation has to be done. At least in NCLT Bangalore, that's what we are settling more matters because they are not hearing matters. They are also find one disposal. That's what where the lawyers meet eye to eye. We see the practicality. That's what we push. Even in arbitration, we see who's on the other side. In many cases, the arbitrators are also facilitating. Sooner than later, we try to settle these matters and bring a quietness to this. So, sir, be rest assured, we act responsibly.
When I said arbitration bar, if both the advocates fall in the category, there is no problem. That's what I've been telling you. In fact, in Bangalore, these transport matters, the entire litigation only if you have, because if others enter, they don't know what to do. How to run the bus, they don't know. Similarly, if a strong arbitration bar develops, these part-time workers can't enter. Persons who only practice after 5 o'clock, only practice on holidays, they will become trouble. So therefore I said, in the beginning somebody has to make a sacrifice. And in the interest of the bar, arbitration bar, and in the interest of administrative justice, in the larger public interest and the business. Because everybody in the end of the day is looking into business. By this sacrifice you lose nothing, according to me, you stand to gain. That's what I meant. I did not say irresponsible lawyers. I said
Thank you to all of the panelists for their insightful thoughts this afternoon. We will now open up the floor for questions.
Good afternoon, everyone. My name is Rahat. As someone who has received training at the academy, Justice Kumar had always insisted the importance of fundamentals. So when we are talking about investor disputes and shareholders issues, the foremost thing that occurs to me is the drafting of the agreements itself. It goes to that basic as to why we should not leave the clauses open-ended and have clarity in the clauses. The second thought that I would want to share is, when we have mediation as a precursor to the commercial disputes, could we give a thought to mediation as a precursor to pre-arbitration thing? That could also be a thought to kind of dwell upon. And also we see that in most of the contracts, we have only 1 or 2 clauses with regard to arbitration, as like if this happens, this is going to end up and this is the law that would be governing. We never have really given a deeper thought to having an extensive arbitration agreement itself as part of the bigger contract. Because there's so much of scope and autonomy given in the enactment itself to decide upon the arbitrators, the kind of place that we have to choose, the kind of procedure that we want to make it as part of the arbitral process. So probably we could use those available systems already at our disposal to make the system a bit stronger. Thank you very much.
I don't know what others experience. My experience is, I don't think anybody will draft an arbitration clause. They will take it from some other and they introduce it. And they have no idea when they say there will be 3 arbitrators. They have no idea about the cost to be incurred if you are going to have 3 arbitrators. You are right. While drafting the arbitration agreement, you must have a clear notion. If a dispute arises, how it should be resolved. Of course, when institutions draft this, they used to say, my chief secretary, the arbitrator, so-and-so is the arbitrator, and now the Supreme Court has come down heavily, that is not permissible. Now even the law also, it doesn't permit. nonetheless, the fact that today you don't get speedy justice in courts, and therefore you have an alternative remedy by way of an arbitration if you want an adjudication, should weigh with the parties when they are entering into agreement and make suitable provision. And most of the time I find this appointment of arbitrators is taken very lightly. And sometimes I also find the judges who are dealing with Section 11 application thing, when you don't have agreed, I will decide who should be the arbitrator. For more than 5 years I was doing it. Of course I was accused. The reason was, after coming to the conclusion, I used to say, no, I am going to appoint an arbitrator. But the essence of arbitration is the appointment of an arbitrator of a choice by the parties. That's where it stands out from the court. So I used to ask them, please let me know whom you want. I had a list of about 60 judges. Believe me, when I gave the option, the names which they mentioned, it was not more than 5. And I was accused of preferring those judges. Of course, this all happens, doesn't matter. So the essence, if the arbitration succeeds, you must know who the judge is. You can't have any grievance against him. That is the main thrust of Arbitration Act. You select the judge. You parties select the judge. You select the procedure. Invariably, no party will say what is the procedure. Ultimately, the arbitrator will decide. When he decides something, you find fault with this. So, enormous rights are conferred on the parties to a litigation, to choose the arbitrator, the procedure to arbitrator, the place of arbitration. But I find they don't know. I don't know whether they know their rights or not, or they have taken it very lightly. That is the reason, one of the reasons why arbitration is yet to catch up in our country.
Thank you for all the panelists for being as candid on some of the topics. As a disputes counsel, I think it was very therapeutic to hear some of the thoughts being discussed. I think the one question and the elephant in the room comes down to the structure of the Companies Act itself. And sometimes I can't help but feel that we have some of the most over-regulated structures for companies in India compared to other jurisdictions. The issue of what is arbitrable and what is not, do you think somewhere the solution is that we must also address amendments to the Companies Act and probably deregulate a little bit?
Of course, it's a continuing process. Our Indian Constitution is amended 104 times. Company Act also should be amended, is it not so? If you want results. The problem is, before a draft, I don't know whether they are doing it or not, these acts were circulated to all advocate associations for them to have a discussion and give it. I have not come across one association arranging a function to look into these drafts and make any recommendation. The advocates open their eyes only after it has become the law. So therefore don't blame the legislatures. This is the process. Again we have failed. Even now, after deliberations in this, if you are able to recommend something to the central government, certainly they will look into it. But after the function we will go away. We are in a hurry to go back. And we will not spend some time to see what we have discussed, how best it could be put into writing, and how best we can recommend to the authorities to amend the law. If you start the process today, at least after 5 years it will happen. That's why I said we must be more sensitive. We are only interested in blaming everybody except ourselves. It's time that we don't blame others. We will do our duty and we will also contribute our mind to the growth of the law in this country. Yes, company law requires amendment, and you know who drafts the amendment, how the law is passed in the parliament. In spite of it, I think we have the best laws. There are some drawbacks, latches, some additional things have to be said. That people who are practicing should say it, is it not so? There will be one draftsman in the building, and he will be drafting all laws in the same fashion. Because if you leave him, nobody knows what the law is. This again I say, the lawyers have a role, a greater role to bring it to the notice of the authorities, how some of the provisions, many times the judges do it. And because of the judicial pronouncements, law is amended. It's an elaborate procedure. It takes years before a matter reaches the High Court or the Supreme Court for them to do it. But lawyers, an advocate association, of course, we have got numbers. But very unfortunate that nobody worries about the law. Except the law, everything is worried about in that. Though we have experts, they have no place in the advocate association. Persons who have a voice, they are not bothered about this, they are something else. These are the things which we must now give attention to. Advocates Association should take an active part in recommending these amendments after seeing how it has not worked in real life. The legislators will not be knowing it. The rulers will not be knowing. The litigants can't do anything. It is the lawyers and lawyers alone who can bring it with the authorities, the flaws in the law, what additions to be made, what amendments should be made. At least forget about the advocate association. At least that's why I said let us have a arbitration bar. It will not be in great numbers, but the persons who will be involved in this are really efficient. At least they should be able to say what is the law to be changed in the company law or in the Arbitration Act or in other connected matters.
Just one
I think one point that I wanted to add, somebody mentioned about the drafting of the arbitration clause. I feel the importance of a well-drafted arbitration clause comes more in cross-border contracts, because cross-border contracts, I mean, what we typically see is that investors will always insist upon the seat to be either in London or Singapore, right? One must also pay attention to the drafting of the arbitration clause and understand firstly what is arbitrable in these jurisdictions. Because if in India, O&M disputes are not arbitrable as it stands today. Whereas as I mentioned earlier, in Singapore, in London, in Hong Kong, Australia, most of the other Commonwealth jurisdictions, they are arbitrable. So when one is drafting an arbitration clause, importance needs to be given and understanding what it is, because ultimately we have to keep into mind that you are going to, even if like in Anupam Mittal's case, the Singapore Court of Appeals has taken the position that it is arbitrable. In order to execute that award, one has to bring that back in India. And if you have to execute that award in India under Part 2 of the Arbitration Act, then one may tend to get stuck again, because disputes which are not arbitrable cannot be enforced. So that's why the emphasis seems to be, and again, we've thrown up with this entire, Anupam Mittal has thrown up with another new area of the arbitration agreement, which is the Lex Arbitri, which none of us ever have put in any of our contracts. We only have the governing law and we have the law of the seat. But the law governing the arbitration agreement is never paid attention to. And those who have followed this entire case will understand the importance of the Lex Arbitri. Because if that Lex Arbitri was there, probably they would not have wasted 1 year in Singapore, where the Singapore court actually had to determine what is the Lex Arbitri in order to determine whether the dispute is arbitrable or not. So that's just a tip for the lawyers to draft the arbitration clauses more carefully.
One thought on now. The question whether the Companies Act itself requires amendment. So we know it's this been going on 100 years. There are only 3 provisions typically which deal with disputes. One is refusal to register transfer of shares. You have a remedy, go to the Companies Act. The other the old 397, 398, which has morphed into 241, 242, which you all know it is jurisprudential. Over a period, you have decisions after decisions. So these 2 cover. But fundamental thing is, going back to the topic on hand, shareholders dispute. So the law is clear. The Articles of Association is a contract between shareholders, and also once you incorporate it in the articles, as between the company and the shareholders. So if you incorporate these into the Articles of Association, automatically the jurisdiction of the company law board vis-a-vis it is operation mismanagement gets pushed out. You can enforce it as a contract. It may not require very drastic amendments, but overall it is covered. Depends on where you place it and whether you make it an enforceable contract or not.
Here, one thing we must bear in mind is, it is settled law in this country, a forum is to be constituted by a statute. Parties by consent cannot confer jurisdiction on a forum which the forum doesn't have under the statute. So these are the two extremes. One is jurisdiction has to be conferred by a statute on a forum. The other is by consent of parties you cannot confer jurisdiction on the forum which otherwise it doesn't possess. So that is the problem we are facing here. If the law says only the court shall pass a decree winding up order, merely because the parties consent that arbitrator can do, even if it passes, therefore section 34 is invoked and say it is void. It cannot be enforced. It is set aside. So that's where we are caught. That's why I thought the best remedy I could see after this deliberation is let the arbitrator do the case on merits. Let him also say what should be the final order, but that is not final. Then place it before the forum which has the jurisdiction. That report will, that may be a via media, because arbitrator, especially in our country, you are appointing only, no youngsters are appointed. Because in this academy we had a course for arbitrators, 6 months course. People got into it thinking that they will be appointed as arbitrators. In our country it is not possible. The preferred people are retired judges because they have a life experience of 30 to 40 years, some senior lawyers or some experts in the particular field. So therefore, by consent of parties, if you say this particular thing is arbitrable and still the law is coming in the way, it could be referred to the arbitrator who will decide the case on merits, but it cannot be given effect to unless a seal of the court is put. At that stage, that court will have the jurisdiction to either agree with what the arbitrator has said or substitute its reasoning and pass another order. That may be a better remedy because courts doesn't have the time, even doesn't have the expertise. Whereas an arbitrator has all that and what we call a speedy remedy, speedy trials. Everything can possible if it is before an arbitrator, except that he has no jurisdiction to pass the final order. That could be delegated to the court which has the competent jurisdiction, and somewhere it requires an amendment to the law. Again, this can't be done by consent of parties.
Just one word on the over-regulation question you brought up. I'm glad you're bringing it up, although it may really be not within the topic itself, a larger rendition. I've always believed that in a socialist economy, over-regulation is the norm. And that's the difference you see when we do international disputes in terms of how the West looks at the same law, pretty much the same Companies Act vis-a-vis how we look at it. And I say this not really from a positivity angle, but I am very negative about it also. Please do think about it when you go back. Competition law in this country was actually not over-regulated. Light touch approach, section 3 and 4 was essentially an ex-post scenario. You do your business. If you cause adverse effect on competition, that's when I will come in. So it was light touch. Whilst 5 of course was ex-ante and you could look at combinations. But that worked well. But still, our country is not happy with it. Now you look at the digital competition bill that has come in, which is our country going towards being a leader in digital economy. The digital competition bill is completely ex-ante. The issue is that I will first regulate you in terms of how you run the business. It's nothing but over-regulation. So therefore, in the Companies Act perspective, I firmly believe, and I agree with you on that while from the governance of companies, you can be over-regulated, no problem about it. But on the disputes in that, why should you be over-regulated? Like that should be the approach. But I don't know whether the law will change.
Just to your point, I'm Yashasvi.
Oh yes, correct.
And I'm practicing we are going to work together. But just on the scope of judicial intervention in disputes, I mean, whenever we are advising mostly our multinational clients, the two things which frustrate them about the system here is one, of course, the time value of money, which is very, very rarely understood, and also more importantly, the certainty of dispute resolution. And clearly in the hierarchy of things, the NCLT would be the least favored, then you come to the courts, and then you come to onshore arbitration, then you come to offshore arbitration. But even with offshore arbitration, the scope for judicial intervention, whether it is while the arbitration is going on or post the arbitration,
it causes a significant amount of confusion, and that's where I believe that there is indeed a need for legislative intervention, where you reduce or you in fact eliminate the scope for it. Even in a case like Docomo, right? I mean, even after the parties were consenting, the RBI will come in and say that, oh, I still have a role to play here.
I don't think regulators in this country understand light touch as a model. ERA is one example where light touch seems to have worked, and competition as it stands today, light touch has worked. That's another thing for the bar. I think Bangalore bar on the regulatory side is rather weak. It's, I think, a great opportunity for lawyers here to actually get onto that regulatory spectrum. Of course, company law being one part of that regulatory.
Thank you to all the members of the panel and the audience for the questions. Just some short closing remarks. When we reached out to Justice Kumar requesting him to chair this panel, he had only one request, that we draft a broad topic so that the discussion could be meaningful and everyone could share their ideas to better the system. And as a testament to his foresight, we had to add more chairs to the hall for this discussion. We are grateful to all of the panelists for the food for thought that they've given each of us as litigators, arbitration enthusiasts, arbitrators present and future. And we look forward to working together in this ecosystem to make arbitration the most effective mechanism for resolution of of shareholder disputes. I would now request Justice Mudgal and Ms. Manisha Kongovi to present a small token of appreciation to Justice N. Kumar for chairing this panel today. Mr. Puvaya, thank you for being here, for coming all the way from Delhi, gracing us with your presence. I request Manisha to please present a token of our appreciation. To Murli sir, thank you for sharing your thoughts, for helping with the initial discussion as well and directing all of us on this topic. Requesting Ms. Manisha to please present a token of our appreciation. Ms. Pinaz Mehta has prepared for this panel despite being part of the organizing committee, despite all of the arrangements that she's made for us here at the Judicial Academy. Thank you for being here, Pinaz. Please accept a token of our appreciation. Mudyarkar, thank you for posing important questions to us that we all need to consider as lawyers. Please accept this token of our appreciation. It is important for us to recognize that for this initiative to be successful, we've not had only the support of the sitting judges of the Honorable High Court, but we also have the retired Honorable Judges of the High Court who have graced us with their presence today. May I request Justice Nawaz to kindly present our retired High Court judges who have graced us with their presence today with a token of our appreciation for their support. We are deeply obliged for your support, my Lord. We would request everybody to join us for lunch. The next session will be in the main auditorium. We will begin the next session at 2:30 p.m. once again in the main auditorium. Thank you all.
Thank you.
Thank you.
Thank you.